Corporate bylaws are the rules by which corporations operate on a day-to-day basis. The bylaws are generally adopted by the incorporators or the board of directors at the corporation's first organizational meeting, though they may, and usually are, amended later. The terms set forth in the bylaws must comply with relevant state law, and be consistent with the Articles of Incorporation which established the corporation. The Articles of Incorporation generally deal with only the basic corporate structure, and the law allows the corporation great latitude in determining its internal rules. The bylaws carry forward the purpose set forth in the articles by establishing a more detailed rules structure. Unlike Articles of Incorporation, which must be filed with the state, bylaws can be kept private, though many public corporations make their bylaws available on the company's website. Bylaws detail the internal working procedures of corporation. While they can differ by company, bylaws typically address the most important aspects of corporate operations. These include the election and functions of directors and corporate officers, the procedures for shareholder and board meetings, how shareholder voting is conducted, as well as the capital structure of the corporations and methods of fiscal accounting. Each of these areas can be quite complex and vary greatly from company to company. To understand the types of rules which corporations may include in the bylaws, we can use a hypothetical newly found corporation, ABC Corp., and examine some of the bylaws it enacts. ABC has filed Articles of Incorporation, which named a board of directors, and these directors meet at the corporation's first organizational meeting to draw up ABC's bylaws. One area they will cover in the bylaws is the appointment of corporate officers. The board decides that ABC will have a chief executive officer, a chief operating officer, a chief financial officer, a treasurer, a secretary, and a controller. The bylaws also allow a single individual to perform the duties of more than one office, but may not serve in more than one official capacity when executing an agreement. ABC specifies the duties of each officer. For example, the bylaws call for the treasurer to be responsible for depositing and disbursement of ABC's funds, as well as borrowing funds in compliance with agreements to which ABC is a party. Finally, the bylaws provide for removal of officers by the board, with or without cause. They also specify that an officer may resign at any time by giving notice to the board as a whole, the CEO, or the secretary. The resignation is effective immediately unless otherwise specified. Next, the bylaws turn to setting the rules for stockholder meetings. As is common practice, they permit the meetings to be held by remote communication, without requiring attendance in the specific physical location of the meeting. It is determined that ABC will provide a minimum of 15 days' notice in advance of stockholder meetings. The notice will include the place, the date, and the time of the meeting. In case of a special meeting, those meetings which are called in addition to the required annual meeting, the notice must also state the purpose of the meeting. Although all corporate statutes require an annual meeting, ABC's bylaws are written to permit shareholders to compel a meeting if one is not held within 15 months after the prior meeting. Special meetings can be called by the board, or by shareholders holding 15% of the voting shares, or to vote on a merger or other extraordinary action, such as altering the rights of certain classes of stockholders, merging, dissolving the company, or liquidating its assets. The board adopts a provision for the bylaws, which defines a quorum for ABC stockholder meetings as a majority of the votes entitled to be cast by the stockholders who are present, either physically or remotely, or represented by proxy. However, the provision requires that when a vote is taken only by certain classes of shares, in those cases a quorum means a majority of stockholders in that share class. Finally, the directors turn to establishing the bylaws governing voting requirements. First, they enact a basic rule that each stockholder holding common stock is entitled to one vote for each share of stock that he owns. ABC's bylaws also provide for voting by proxy. Any proxy must be presented to the secretary of the shareholder meeting before the meeting starts. The proxy is considered revocable by the shareholder unless it explicitly states that it is irrevocable and the appointment is coupled with an interest, which means that there is consideration for the proxy appointment. Corporate actions are generally authorized by a majority of the votes cast at the meeting. However, directors for ABC are elected by a plurality of the shareholder votes cast. This last provision means that if there's a contested election with multiple candidates for a director position, the one who receives the most votes is elected, even if he or she does not receive an absolute majority of the votes cast. These are examples of the types of provisions that corporations adopt as part of the corporate bylaws. Obviously, each corporation tailors its bylaws to the needs of the business and will vary depending on the size and scope of the corporation. At the same time, many bylaw provisions have been standardized, and specific language of these provisions are frequently adopted and widely shared. Bylaws are generally amended by a vote of the shareholders. However, if the authority to amend is given to the board of directors in the Articles of Incorporation, the board can also make amendments to the bylaws, after providing notice to the shareholders. In some jurisdictions, however, the board of directors is assumed to have the authority to create or amend bylaws, unless the Articles of Incorporation reserve that power for the shareholders. However, the right of the shareholders to amend bylaws does have limits. Shareholders may not amend the bylaws in a way which limits or prevents the board from effectively managing the corporation, or limits its authority to provide for a reasonable, predictable, and orderly process. In an important case, the Delaware Supreme Court ruled that a bylaw proposed by a major shareholder would unlawfully prevent the corporation's directors from carrying out their legally defined duties. The bylaw proposed that the corporation reimburse shareholders for expenses if they nominate candidates for board of directors in a contested election. The court ruled that the directors have a fiduciary duty to the corporation to use discretion to determine whether such reimbursement is proper. Since requiring them to do so would force them to violate this legal duty, the court held that the bylaw violated Delaware law. We have covered some of the most important topics related to corporate bylaws. However, corporate bylaws govern all aspects of a corporation's operation, and so their terms are wide-ranging. The best way to get a full sense of the scope and detail of corporate bylaws and the different kinds of rules that corporations employ is to read the bylaws from a variety of corporations. Corporate bylaws, as well as articles of incorporation, are generally accessible on the websites of major corporations and can be read and contrasted with those of other companies. For the full text of the bylaws provisions referenced in this presentation, please see the text below.